So we have David first.
Good afternoon, everyone. I begin by thanking the clinic for honoring me with the opportunity to speak to you, congratulating the clinic on this tremendous anniversary, and embarrassing Avi. I've had the privilege of working with Avi in advocacy on human rights reform issues together, and it's been a real honor and a privilege. You will find no more effective, more principled, no more respected, and no more liked advocate than Avi. And it's been a delight to work with her and continues to be. The charter was passed 30 years ago with a whole bunch of rights in it after a big long debate, and during that big long debate only one right was added that had been left out of the original draft, and that was equality for people with disabilities. There was a section 15 in the original draft of the charter. It included various grounds. It did not include disability, and it was worded in a way that would preclude disability claims. It was the advocacy efforts of many people with disabilities before Twitter, Facebook, computers, even fax machines, that persuaded the governments led by the federal government to amend the charter. During the patriation debates, the only substantive right added was the disability amendment. I had the privilege, while in this room supposedly hearing Bard Mission lectures, to prepare and present as one of the presenters before the Joint Special Committee in Ottawa that was holding hearings on the charter. What did we win? Well, lawyers usually talk about cases, and yeah, we've won some very important cases. 97, Supreme Court of Canada decides the Eldridge case, says deaf people, when they go to the hospital, should be able to communicate with their doctors. That should be a tough one. But it also said that when governments make and apply programs and policies, they've got to take into account the needs of people with disabilities. That shouldn't be a tough one, but it still is. A year or two ago, federal court decided that when the government posts information on a website for the public to use, people like me who are blind and use alternative adaptive technology should be able to access that information on the web by ensuring it's presented on the internet in a way that is accessible to us. That should be a no-brainer, but the federal government fought it up 2 levels of courts, lost all the way. We've also had cases that we won at lower courts and then lost on appeal. Our Court of Appeal wisely decided that blind kids have a presumptive, kids with disabilities, all disabilities, have a presumptive right to go to school with their peers of kids without disabilities. If the government wants to segregate them, they got a burden to justify it under Charter Section 1. Supreme Court of Canada reversed that one in about 12 hours. The case is called Eaton. It's bad. But I don't want to talk to you about cases. I want to talk to you about what else the Charter has done. The Charter made an entire series of generations of people with disabilities aware of new rights, and also aware that it's impractical many of the times to fight them, fight the barriers we face through legal action one at a time, whether it's under the Charter or the Human Rights Code. It takes too long. It's too fatiguing. We often don't get access to lawyers. Even when we used to have a public enforcement agency to back us in Ontario, the Human Rights Commission under the Human Rights Code, that was principally taken away from us in 2006 when the Ontario government wrongly privatized human rights enforcement. So while we need resort to case-by-case litigation, for most people with disabilities who are unemployed or underemployed, who are overrepresented among those who don't work, overrepresented among those who don't work, and overrepresented among the poor, underrepresented among those who could afford lawyers, for them, they needed something else. That led to a movement which was inspired by the Charter and the Human Rights Code back in 1994, and I've had the privilege of serving in a volunteer leadership capacity. It was a movement to get a new law passed, not to change the rights that the Charter and the Human Rights Code guarantee us, but to make sure people actually start honoring them. What we wanted was a new law that would ensure that we would get access to the goods, services, jobs, and facilities, the opportunities that people without disabilities take for granted, without having to sue to overcome those barriers one at a time. If you've heard me speak before, you know what I'm about to do. Pretend you don't. Let's see if this touches you and affects your life. I want to see if you are affected by this issue. I'm going to embarrass you publicly. I would like you to raise your hand, please, if you have no disability now and you are positive you will never get one. Raise your hand. I look around and I don't see any hands. We are the most peculiar minority of all, for we are the minority of everyone. Everyone either has a disability now or will get one if they live long enough, or has someone near and dear to them who has a disability. That's what drove us to call for a new law that would remove the barriers we face and prevent new ones from happening again. We got a weak law in 2001 called the Ontarians with Disabilities Act from the Mike Harris government. We kept fighting till 2005 and won a stronger law, the Accessibility for Ontarians with Disabilities Act 2005. Now, if you want, moment, pause, shameless plug. If you want to learn more about this, Clara's going to pass around 3 things. A pad. On that pad, if you want to get our email updates, learn about our campaign for accessibility, find out what we're up to, print legibly your email address. Second, if you want to know more about us, a fact sheet's going to be given to you. It'll also tell you how to follow us on Twitter @AODA Alliance. Or if you're watching this on video and you want to know how to contact us to get our email updates, just write aodafeedback@gmail.com. And a third page, which I'm going to get to in a moment, but which will be passed around. What did we win in the Disabilities Act? Well, we won a good law. It does something that we believe no one else has gotten in the campaign for equality before. It sets a deadline. It says that by the year 2025, people with disabilities in Ontario, we number over 1.7 million, and we include everybody ultimately, we're entitled to have a fully accessible society. And it requires the government to develop, enact, and enforce accessibility standards that will get us there. So how are we doing? Well, according to an independent review undertaken by the government, by an individual named Charles Beer, whom the government appointed, who reported in early 2010, the government needs to revitalize its implementation of this legislation, breathe new life into it, stop dealing with it as business as usual, show new leadership if we are to achieve full accessibility by 2025. And we agree. My coalition's been actively involved in trying to come up with proposals for how to strengthen this legislation so that it has as good an impact as it can. Now, it's had some real significant impact, and we're proud of that, but there's a lot more that needs to be done and can be done even in a weak economy. Let me just conclude by giving you one example, and we trace this example all the way back to the days that Chief Justice McMurtry was talking about, the heady days of fighting for the charter, and it leads all the way up to events of just 2 hours ago. Rights don't mean anything unless they're effectively enforced. And we have learned from decades of experience with the charter, that the cost of enforcement and the burdens of case-by-case enforcement are often just things that people with disabilities can't bear. So when we approached the political parties, we're nonpartisan, and asked for a strong Disabilities Act, one thing we wanted was to ensure that it was effectively enforced. A resolution was passed unanimously 14 years ago at the end of this month, October 29, 98, led by the Liberals in Ontario and supported by Dalton McGuinty, then in opposition, promising, among other things, effective enforcement. The law that was passed in 2005 has good enforcement tools, but we don't think they're being adequately deployed. At the very least, and as a very first step, we need a phone number that we can call in Ontario to report barriers and ask for action. There is none. So 2 hours ago, this is that last piece of paper you got, we unveiled our latest strategy, and with this I will close. Our strategy is to ask the government to simply set up that phone number so that we could get some effective enforcement. Because nobody else will give it to us, our solution is dial Dalton. You'll see a page which invites you, starting on the 14th anniversary of that pledge, to call the guy who made it and ask, who do we call? Tell them about barriers you know about. This has already been retweeted to 80,000 people in the past 2 hours. And using the same strategy that helped us win the amendment to the charter without that technology, using the same strategy that helped us win the Disabilities Act, our aim is to win effective enforcement and to win it now. Thank you very much.
Thank you, David. I forgot to mention earlier, we'll have a chance to ask questions after all the panel members have finished speaking.